Good morning. My name is Faith Johnson. I will be your affirmative speaker today. Thank you so much for judging, Mrs. Jensen.
My name is Abigail, Giles, and I'll be representing the negative side. Thank you so much for your time.
And before we begin this round, I'm sure both my opponent and I would like to know if there are things you prefer to see or not see in today's debate round, or if it came down to a close call, what would be something you would decide off of?
Well, this is my first time judging this whole year, so I'm really excited to do it again. But I've judged a lot in the past. I like double tagging or anything that makes it very easy for me to take notes on what you say. If I don't write it down, I might forget you ever said it, even though it's brilliant. And let's see, if it came down to deciding, I really appreciate that this is Lincoln Douglas value debate, so I really want to hear a lot of value and related things like logic, ethics, and as opposed to just application type.
All right. All right, is my judge ready? My opponent?
Yes.
6 minutes. Sounds good. All right, let's begin. Justice Anthony Scalia was a great Supreme Court judge. He did not make up constitutional rights or wander from the language of the Constitution. He believed firmly in the letter of the law, and in 2015 he gave a speech in which he summarized his legal philosophy. Quote, "The Constitution is not a living organism," he said. "It's a legal document, and it says what it says, and it doesn't say what it doesn't say," end quote. It's because I agree with Justice Scalia that I affirm the resolution. Resolve, the letter of the law ought to have priority over the spirit of the law. Let's look into a couple of definitions. First, the definition of letter of the law. According to Merriam-Webster Dictionary, the letter of the law is, quote, exactly what the law says, end quote. This is not complicated. We look at the text of the law and follow the plain meaning of the words in the law. Spirit of the law, according to the Judgment and Decision-Making Journal, is, quote, here the spirit of the law is its perceived intention, end quote. And then finally, definition of have priority. According to Merriam-Webster, have priority is, quote, to require being dealt with or done first, to be more important than something else, end quote. Let's look to a resolutional analysis point, which you can simply tag as prosecution. Again, prosecution. Vocabulary.com defines prosecution as, quote, the institution and conduct of legal proceedings against a defendant for criminal behavior, end quote. In other words, it's the process by which an individual is punished when breaking the law. In the context of the resolution, we're looking at when a law is administered. My value is justice. Justice is defined according to Cornell law as, quote, justice is a legal system or structure that is designed to judge in a general sense who should be accorded a benefit or burden when the law is applied to a person's factual circumstances, end quote. Justice includes equality in punishment and clarity in applying that punishment. Let's look at my first main argument or contention, which you can write down as the letter of the law protects justice. The letter of the law protects justice. When a judge is making a decision based on a law, his first question shouldn't be, I wonder what was the intent behind the law. His first question should be, what does the law say? Let's look at two examples. First example is sentencing boundaries. Against sentencing boundaries. In sentencing criminals, the judge's sentence must be within the boundaries set down by the law. And these judges know the boundaries. The Department of Justice states, quote, Congress has established minimum and maximum punishments for many crimes, which the judge uses to craft a sentence, end quote. There are many factors that are considered when giving a punishment, like did the criminal commit the crime before? How much of something did they steal, or did they hurt anyone when doing the crime? But the boundaries are clear and specific, and they describe the punishment that should be given depending on the severity and impact of the crime. The letter of the law specifies a range, and the judge does not depart from the letter of the law as long as he stays in that range. The judge's default position is to look at the law first. So let's look at the second example. Second example is speeding tickets. Again, speeding tickets. When someone goes over the speed limit, a police officer gives them a ticket. If the speed limit is 65 miles per hour, then someone going over 70 should get a ticket. Now, my opponent might say, it's impossible to ticket everyone going 1 mile per hour over the speed limit. Here's the important point. even if a person going 1 mile per hour over the limit is ticketed, the police officer still looks to the letter of the law to decide if someone should be ticketed. The police officer has to look at the law first in order to know what is punishable and what is not, even if he only punishes people 5 miles per hour over the speed limit. In other words, we look to the letter of the law first and we prioritize the letter. The impact is that justice is achieved. Again, justice is achieved. But let's look at the flip side of this in my second main contention, which you can tag as prioritizing the spirit of the law undermines justice. Prioritizing the spirit of the law undermines justice. Problems arise when judges decide that they're going to prioritize the spirit of the law, because that leads to widely different interpretations and vagueness of the law. We can see this in my third example of Roe versus Wade. Again, Roe versus Wade. One of the most famous examples is Roe versus Wade, when in 1973, 7 Supreme Court justices announced that the Constitution protects abortions. Although the Constitution doesn't use words like abortion, medical procedures, and operation, or anything else describing the subject, 7 of the 9 Supreme Court judges ignored the letter of the law and imposed on America their own public policy. They took their eyes off of the letter of the law. The impact is that justice is failed. Again, justice is failed. Now, I am not arguing that my opponent in this debate round must defend abortion. Rather, I'm simply asking that my opponent acknowledge that huge problems arise when judges take their eyes off of the letter of the law. When judges start thinking about what the law implies instead of what it actually states, unjust decisions arise. It's for all of these reasons that the letter of the law must be our priority. Thank you so much. I now stand open for cross-examination.
All right, 3 minutes?
Yes.
We're all ready? Then let's begin. Okay, can you define justice for me?
Yes. Justice, according to Cornell law, is, quote, justice is a legal structure or system that is designed to judge in a general sense who should be accorded a benefit or burden when the law is applied to a person's factual circumstances, end quote.
Okay, so in simple terms, it's basically giving each their due. Is that right?
Pretty much, yeah, that's kind of the idea.
Okay, and then for your application of Roe versus Wade, what law was being violated here? Like what direct law?
Specifically, they were violating the law of this, I believe it was the Second Amendment, which was to privacy, I believe.
Okay, and then can you read your definition of the spirit of the law?
Yes. My definition of spirit of the law is, quote, here the spirit of the law is its perceived intention.
Okay, and then is there a difference between the perceived intention and the aim or purpose of the law when it was written?
I think that they tend to go hand in hand because the purpose behind the law is extremely difficult to find. And so anytime we try to look for the spirit of the law, we tend to fall into a perceived intention.
Okay. So the perceived intention, though, how do you find what the perceived intention is?
Perceived intention is how people examine what the purpose of the law probably was, what people decide.
Okay, and is it your stance that the spirit of the law is subjective?
I think that most of the time it is subjective.
And then, okay, could you summarize your application of sentencing boundaries?
Yes. So when a judge gives a sentence, they have to stay within the boundaries that are required by law. They can't go outside of them, so they always have to adhere to the letter.
Okay, and does the spirit of the law go outside of the boundaries?
Yes.
Okay, and then, sorry, back to the spirit of the law definition. Can we agree that the spirit of the law is singular here?
Spirit of the law, yes, I believe it is singular.
So
yes.
We're talking about one spirit of the law and one letter of the law, is that correct?
I think that we're looking at a general principle, letter of the law and spirit of the law. I don't think there's a difference between whether or not it's plural or singular. I think it's just a general principle.
Okay. Do you know what the Second Amendment is?
Yes, I believe the Second Amendment is the right to bear arms, I believe.
Okay, so can we agree it allows you to keep a gun?
I think that in that instance, yes, it does agree. Yeah, it does agree to let you keep a gun.
Okay. And then can we agree that if you're following this super strict interpretation of the letter of the law, that you could say it allows you to keep a gun but not fire it because it says bear arms?
No, because it says it shall not be infringed. So government cannot put a law saying, oh, you can only shoot at this person or whatever. It shall not be infringed. So under the letter of the law, we can still see a protection.
Okay, no further questions, thank you. Okay. Starting 4 minutes of prep time. Stopping prep time with 1 minute and 27 seconds. Okay, 7 minutes. My judge is ready? My opponent? Yes. Then let's begin. It is the spirit and not the form of law that keeps justice alive. It is because I agree with the former governor of California, Earl Warren, that I negate today's resolution. Resolved, the letter of the law ought to have priority over the spirit of the law. Let's look at the framework of the case first before getting some key responses and a case of my own. So first, I agree to her definitions of the letter of the law and priority, but I would like to offer a counter definition of the spirit of the law. And that is defined by Merriam-Webster as, quote, the aim or purpose of a law when it is written, end quote. And there are a couple reasons that this is the definition we should be using. And the main one is if you can tag as original intent. That's again, original intent. But why is this important? Well, subpoint A, you can tag as not subjective interpretation. That's again, not subjective interpretation. We're not looking at a subjective interpretation of the spirit of the law. We're looking at the aim or purpose of the law when it was written. And you might be wondering, how do we figure out this aim? Well, there are two ways to find this. And first is through surrounding documents. Surrounding documents. You can find this through surrounding documents of the time when it was written and looking at the context of this. But the other way is through other words or works of a person. It's again, other words or works of a person. So the way that we can look at the spirit of the law and what is the intent of the law is through surrounding documents in the context of the time and the context of the person and other words and things that they have written. So it is in this way that the spirit of the law is not subjective when looking at the original intent. Now let's move on to her value of justice. I agree to this value, and this is the value that I'll be using throughout today's round two. And I agree to her definition too, which is basically in simple terms to render each their due. But the reason to prefer this value on the negative side is that it's embedded in legal documents. That's again embedded in legal documents. The Constitution is one of the original documents our founding fathers wrote. Many legal cases address parts of it. And our Constitution states it is in order to establish justice. So since we are debating how laws should be interpreted today, it's important to look at this. Let's move on to her first contention of how the letter of the law protects justice. You haven't actually tagged my response with my own contention. What you can tag is the letter disregards justice. This is my first contention too. The letter disregards justice. When the letter of the law is prioritized, judges are restricted to the exact wording of the text. And oftentimes, even the best laws lack clarity or are worded in ways that cause confusion. In my own application like this, you can tag as Kaylee Morgan. Kaylee Morgan. A homeschool mother named Kaylee Morgan was pregnant and put on bed rest. She had a few library books checked out that were overdue. However, the library saw this as her breaking the letter of the law. Then she did return the books when she was able, but they said she broke the letter of the law by owning something the library marked as not rightfully hers anymore. They charged her with a Class C misdemeanor in Texas. A Class C misdemeanor is for property theft under $100. However, they never called her about it and she never received a notice. As a result, what became a warrant out for her arrest. When she went up to court, the judge upheld the spirit of the law, and a mere $2 library fee for overdue books turned into a $570 fine for a misdemeanor and a trial. This is unjust. Judge, would you like to be the next homeschool mom facing charges when you unintentionally broke the letter of the law due to providing for your children? Or do you want the judge to look at the context surrounding this law and give you an exception when it is necessary? Let's look at her application of sentencing boundaries. You can tag my response as the spirit of the law is within these boundaries. The spirit of the law is within these boundaries. She talked about sentencing boundaries and how there's boundaries here that fits in the letter of the law, but the spirit of the law also fits in. When we're looking at the aim and purpose of the law, we're looking through surrounding documents and other words or works of that person. We're also looking at the intent, and there is boundaries that have to be applied here. So I believe this is a non-unique example and application that applies to both sides. But then to her application of speeding tickets, you can tag my response as letter is flexible. So again, the letter is flexible. Now, Officer Margarito Meza, spokesperson for the California Highway Patrol, said, quote, driving the speed limit is what is recommended, but obviously there are multiple things that to take into consideration when considering one's speed, such as light or heavy traffic, weather conditions, roadway conditions, end quote. So the letter of the law is flexible here. If there's no one on the road, you can drive faster. If you're driving in a hurricane, you should probably drive a lot slower. The letter of the law is not exact here, so the spirit of the law can be applied. But now let's look at her second contention. She talked about how prioritizing the spirit of the law undermines justice. My response is my own second contention of how the spirit upholds justice. Spirit upholds justice. When we look at the context of the text and the aim or purpose of it, we can truly uphold justice. My own application under this is originalists. Originalists. From the National Constitution Center, quote, originalists believe that the constitutional text ought to be given the public meaning that it would have had at the time that it became law, end quote. In the Supreme Court, originalists look at the Constitution and the text surrounding it. They use the spirit of the law to uphold justice in their decisions. You may be wondering how they find this intent. Well, it's through what I mentioned earlier. You look at other surrounding documents and other words or works of the person. This method of looking at the surrounding context truly upholds justice because it looks at the goal or intent of the law and applies it to situations when it is necessary. But now let's look at her application of Roe versus Wade. You can tag my response as not the original intent. Not the original intent. Justice Clarence Thomas explained that the 14th Amendment never applied to giving the right to women to abort their babies. In this concurring opinion in the Dobbs versus Jackson decision, but specifically to Roe versus Wade, Justice Thomas said, quote, such a right is neither deeply rooted in this nation's history and tradition, nor implicit in the concept of ordered liberty, end quote. We can see here that they did not prioritize the letter of the law. They did not look at the intent of this amendment. This was never the intent of what should have happened. For these reasons, a negative ballot is warranted. Thank you. And I now stand ready for cross-examination.
All right, is my judge ready? My opponent?
Yes.
3 minutes?
Yep.
All right, then let's begin. I want to address this point that you brought up when you talked about the sentencing boundaries in response to my examples of sentencing boundaries. You basically said that spirit of the law is within those boundaries. How can we determine how far spirit of the law can go?
Well, it's through what I mentioned earlier of looking at the original intent as well as the surrounding documents and the other works of this person. So this sets a precedent of how far you should go. Like, you shouldn't look at everything in the perceived intention, but what was actually the aim or purpose here.
Okay, so let's talk about this. You brought up and basically said you could find the spirit of the law through, you said, original intent, surrounding documents, etc. What documents do we look at in order to determine the spirit of the law?
So when the law was written, we can look at surrounding documents of that time and what other things that the person wrote in those documents to better understand the context.
Okay, what documents?
Are you asking like about a specific law or just in general?
Yeah, so if a law is made, what documents do legislators go to in order to find out the aim or purpose?
The Constitution, the Declaration, like Bill of Rights, America's founding documents.
Is it your stance that the Constitution and the Bill of Rights gives us all the information we need to know the purpose behind every single law created?
No, which is why we also look at the other words and works of that person.
So we look at like their books or like their autobiographies?
Things that they've done and said and maybe letters they've written, and if you look at all the surrounding context, then you can get an idea of what the intent was when it was written.
Okay, do you agree people change?
Yes.
Okay, so would you agree that one person might say one thing at one time and then say another thing at another time, correct?
Correct.
Okay, so you would also agree that we cannot read the minds of individuals, correct?
Not entirely, but you can tell what they meant by it by doing enough research in most scenarios.
Okay, but back to my question, you do agree that we cannot know what's exactly inside a person's head, correct?
Not exactly, no.
Okay. Let's go to your, you talked about the application 1 of the Kelly Morgan, basically this woman who was fined for not returning library books. Why did the government or the person arresting her, why did they never tell her that she was breaking the law?
She wasn't aware. I believe they sent her a notice to an address they were no longer at, and they weren't actually looking at the context of what was going on, but looking at the strict law.
Okay, so you said that they did send her a notice and tell her, hey, these books are overdue, you need to return them, correct?
I believe they did, but she never received the notice, and they never called her to make sure she was aware.
Okay, who was the fault in this example that it didn't get to her? That the letter didn't get to her? Whose fault was that?
I believe the government or the Texas administration of whoever.
Okay, so this wasn't necessarily the letter of the law or spirit of the law, correct?
Well, it was the government here, so it was the letter of the law that they were holding her to and saying, you didn't return these books, you should be fined, whereas they didn't understand the context of what was happening.
Interesting. All right, no further questions.
Thank you.
Starting 4 minutes of prep time now. drive time needed? 2 minutes, 25 seconds remaining. Alright, is my judge ready? My opponent? Yes. This is 4 minutes? Correct. Alright, let's begin. I want to start off with an observation point, which you can simply tag as what is foundational. Again, what is foundational? I want to bring you back to the definition of half priority that my opponent did agree to. It says, quote, to require being dealt with or done first, to be more important than something else, end quote. What does this mean? It means that our question in today's debate round is, should the letter of the law or the spirit of the law be the first thing we look at, and which one is more important overall? When we look to a government, ultimately the letter of the law is most important because that is what gives us the foundation to even work with. If our first decision is always to, oh, what was the intent of the law, we could go very far directions in what interpretations we make. Our first default position must always be the letter of the law because it's more important. Spirit of the law does have some benefits, but it's ultimately not most important. Let's look to the definition debate. She brought the new definition of spirit of the law, and she brought up a couple reasons under here. My first response is spirit of the law is very difficult. Again, spirit of the law is very difficult. Again, my point here is that the spirit of the law is very hard to determine. And why? Second response is should never be what we look at first. Again, it should never be what we look at first. Ultimately, the spirit of the law is very hard to determine because we don't know exactly what we're looking at. Now, my opponent said, oh, we can go look at documents, but what documents? Should we go look to their writings about who they are as a person? Should we go to autobiographies? Should we go to other laws? We have this very much of a doubt and a lot of questions to be answered. And so the negative side really hasn't shown exactly what we're doing. So let's go down now to my own application. She talked about basically to the sentencing boundaries. She said spirit of the law within boundary. My response is spirit of the law goes beyond. Again, spirit of the law goes beyond. It's important to understand here that the spirit of the law is the intention or purpose or the true intention of a law, which means that we're not looking to what the law says, but rather what it implies. So that would make it perfect sense for someone to say, oh, I'm going to give a higher sentencing because I believe this upholds the aim of the law. So spirit of the law definitely goes beyond these boundaries. To the idea of the speeding tickets, she said letter of law is flexible. My response is how much? Question mark. Again, how much? Question mark. Again, she said it's flexible, but again, we have doubts and questions as to how much is it flexible. The law, when we're looking at specifically the law is a law. It is not recommended, and that's my second response. Again, law, not recommended. She brought up this example basically saying about how speeding limits are recommended. They are ultimately laws, they are not recommendations. This is pretty clear because we get tickets if we go over it. So the idea of Roe versus Wade, she said was not original intent. My response is spirit of the law abused. Again, spirit of the law abused. Ultimately, they were trying to look for the intention, the aim or purpose, and we got Roe versus Wade. Spirit of the law did not uphold justice. To the application 1 of the Cowley versus Morgan under her first contention, my response is bad government. Again, bad government. And my second response is no specific intention made clear. Again, I'll say that again, but no specific intentions made clear. This is really important because we don't really understand why these officers just went and arrested her. Did they have miscommunication? The letter didn't even get to her, so we can't just put all the blame on the letter of the law because this was a miscommunication problem. And really, these officers didn't really take the right steps. You typically have to tell someone if you're going to arrest them. But to the application 2 of the original lists, my response is how. Again, how. Again, we have uncertainty about where to look to when we look for the spirit of the law. It's because the letter of the law must be our default position. This is why I would ask for an affirmative ballot. Thank you so much.
"27 seconds. ready?
Yes.
Am I a judge? 6 minutes?
Yes.
And let's begin. I'd like to start off with a simple observation point, and that you can tag as original intent. That's again original intent. When looking at the spirit of the law, we should be looking at what is the original intent of the law when it was written. My definition of the spirit of the law is the aim or purpose of the law when it was written. Here we're looking at the original intent, not the perceived intention now, but what is actually written. And it's in this way, it's not subjective. But I'm going to go through some responses and then get into some voting issues to finish off the negative side for today's round. So first, let's look at the definitions debate. She responded to my definition of the spirit of the law, which she said the spirit of the law is very difficult and we should not look at it first. You can tag my response as not exclusive. That's again, not exclusive. My opponent talked a lot about how we should always look at the letter of the law and we should never look at the spirit of the law first, but we're not excluding things. And I certainly believe that there are times when we must look at the letter of the law. But in the same way, there's times when we must look at the spirit of the law. And as a general principle, the spirit of the law must be prioritized and it must come first. Let's move down to my case. She said in response to my first contention and application of Haley Morgan, of the specific intent was not clear here and this was bad government, you can tag my response as strict wording. So again, strict wording. In this example, they were following the letter of the law and the strict wording of the law. That's what the intent was. Even if this was the bad government, that's the point, is this government was following the letter of the law and this is where it results. Whereas if they had followed the spirit of the law, there could have been a much better result here. Now let's look at her application of sentencing boundaries. I said that the spirit of the law is within these boundaries. She said the spirit of the law goes beyond. Well, I still stand that the spirit of the law is within these boundaries, but you can tag my response as intent versus aim or purpose. So again, intent versus aim or purpose. Either way, with the letter of the law, you do have to look at the intent of the words. So the letter of the law can be subjective as well. The spirit of the law is not this perfectly subjective thing where the letter is perfectly objective. It is the same. Not that they're exactly the same, but with the letter of the law, you have to look at what the word means. Whereas the spirit of the law, you're looking at the aim or purpose when it was written. You're looking at surrounding documents, other words and works of this person, and the original intent. But now let's look at her application of speeding tickets. She gave two responses. One was how much, and the other one was this is a law, not a recommendation. You can tag my response as, quote, ideal conditions, end quote. Quote, ideal conditions, end quote. I believe that the law says this is the speed limit in ideal conditions. So the letter of the law is flexible here. The conditions can change. This is very important and a key argument that you should keep in mind throughout the rest of the round. Now let's look at her my second application of originalists. She asked how they decide this. That was basically a response. You can tag my response as when written. That's again when written. And this goes back to the whole original intent argument. We are looking at the aim or purpose of the law when it was written. What is the original intent? And again, the two ways to figure that out are the surrounding documents at the time and other words or works of that person. But now let's look at how her application of Roe versus Wade. She said that this was the spirit of the law abused. And I have two responses. The first is anything can be abused. So again, anything can be abused. Sure, the spirit of the law was abused here, but this was not an accurate representation of the spirit of the law. Like Justice Thomas said, this was never the intent. So this actually was not the spirit of the law here. My second response is the letter of the law has loopholes. The letter of the law has loopholes. She says the spirit of the law can be abused, but so can the letter. There are loopholes within the letter of the law that you can get away with. And this goes to resolution analysis of prosecution. There are loopholes within the letter of the law that you can get through but if you don't prioritize the spirit. However, with the spirit, it is clear what the intent is. But now let's get into some voting issues to finish the round, or the negative side of the round. My first voting issue you can tag as what does the spirit mean? What does the spirit mean? This is important to look at through the round. What does the spirit of the law mean? What are we looking at here? Subpoint A is original intent. So again, original intent. We're looking at the aim or purpose of the law when it was written. We're looking at the original intent of this law. But subpoint B you can tag as not subjective. That's again not subjective. If we look at other surrounding documents and other words or works of that person, then this is not a subjective thing. This can be as objective as the letter of the law, because with the letter of the law, you have to look at the intent of the word as well. But now my second and final voting issue, you can tag as justice is the highest value. Once again, justice is the highest value. And I know my opponent and I have agreed on the same value, so of course justice is going to be highest. From subpoint A, you can tag as the letter of the law violates justice. The letter of the law violates justice. Just like we have seen through my application of Keeley Morgan. They followed the letter of the law here. And what happened? Justice was violated. It is because she said there was bad government here, but that's exactly the point, is they focused on the letter of the law. That's where they took a wrong turn. And this is where justice was violated. But subpoint B, you can tag as the spirit upholds justice. Spirit upholds justice. Let's look at originalists. They uphold the spirit of the law, and justice is given to each their due. It is for all these reasons and more that I would urge you side with the negative. Prioritize the spirit, prioritize justice, vote negative. Thank you.
All right, resuming affirmative prep time, 2 minutes, 25 seconds. Is my judge ready? My opponent? Yes. This is 3 minutes? Perfect. All right, let's begin. I want to ask you a simple question. Would you prefer to live in a world where the first thing judges ask is, what was the intent behind this law? Or judges ask, what does the law say? Ultimately, it is not a judge's decision to decide if somebody has, quote, broken the spirit of the law. Have they broken the exact wording of the law? This has to be our foundation, or else we all of a sudden have unstable ground and anybody can be punished for anything. It's for these reasons that I still believe an affirmative ballot is warranted. Let's look at a couple voting issues. My first voting issue you can tag is justice. Again, justice. Subpoint A, is it clear? Again, is it clear? This is the first question we have to ask when evaluating justice. The second question is it foundational? Again, is it foundational? Which one gives us a better foundation for figuring out how our government should work? So with that being said, I'd like to look at the second voting issue, which you can simply tag as negative burden failed. Again, negative burden failed. Why? Subpoint A, unstable ground. Again, unstable ground. I want to briefly talk about the idea of the speeding tickets as well as her application of the original lists. Again, she talked about how basically we can look to when it was written, and we have ideal conditions when you can break the letter of the law of the speed limit. But again, my question is, what are the conditions? Again, what are the conditions? What are the conditions we're going to go off of if we decide to break away from the letter of the law? What works do we look to when trying to find the purpose of a law? This leads me to my subpoint B of no examples of letter of the law at fault. Again, no examples of the letter of the law at fault. I want to expand on this a little bit as we take a look at her application 1 of Kelly Morgan. Basically said she said it was strict wording. My response is bad implementation. Again, bad implementation. The point I was making with this argument is that this isn't the fault of following the letter of the law. This is just a fault of people not really doing their job well and saying, oh, somebody broke the law and we're not going to tell them and we're going to go arrest them. Even though they sent the letter, it didn't get to her and there were just factors in here that just didn't play out correctly. We cannot put all the blame on the letter of the law. But let's look at this next idea. I want to talk about how basically she said it's non-exclusive. Neither one of them are exclusive. This is going to lead to my third voting issue. The third voting issue is that the affirmative burden is upheld. Again, the affirmative burden is upheld. Why? 2 reasons. Subpoint A is letter of the law is our default. Again, letter of the law is our default. And then subpoint B, clear and specific. Clear and specific. The letter of the law has to be our default position. It is clear and is specific and it doesn't give us unstable ground. It's for all of these reasons I would ask for an affirmative ballot. Thank you so much. Thank you so much for teaching me, gentlemen.
Great job, girls. That was a great round.
Very good round. It was fun.